All right, let's talk about something that sounds super simple but isn't. What does it actually mean to win a lawsuit? You'd think it's obvious, but a recent Supreme Court case just took that question and turned it into this incredible legal puzzle. And believe me, the answer they came up with, it has some massive consequences. Okay, so just imagine this for a second. You sue someone or some entity, and you get exactly what you wanted. The thing you were fighting against, it's gone for good. But the case itself just kind of fizzles out. It ends on a technicality with no final, official, you win from a judge. So, did you really win? No, this isn't just some philosophical question for a law school exam. It has huge, real world, dollars and cents consequences. And that's the core of the story we're going to get into today. So, where did this whole thing even begin? Well, it all started on the road with a problem that was affecting thousands and thousands of people. A situation where a simple, unpaid fine could spiral out of control and cost you your driver's license.
So here was the deal in Virginia. There was this law on the books that said if you had unpaid court fines, your driver's license was automatically suspended. And when I say automatically, I mean it. It didn't matter why you couldn't pay. It didn't matter if you were choosing between paying that fine or, buying groceries for your family. If the money wasn't there, poof, your license was gone. Well, a group of these drivers decided to fight back. They banded together and filed a lawsuit, and their argument was pretty straightforward. They said it was unconstitutional to take away their ability to drive, to get to work, to pick up their kids from school, without at least considering if they could even afford to pay the fine in the first place. This was a powerful argument, and it totally set the stage for a major legal showdown.
And right out of the gate, in that showdown, the drivers scored a huge early win. But to understand just how big this was, we've got to talk about a really important legal tool. And that tool is called a preliminary injunction. Now, the key phrase you got to focus on here is likely to win. See, a preliminary injunction isn't just some simple pause button on the case. To get one, the drivers had to convince a judge that their core argument was so solid, so strong, that they were actually probably going to win the whole thing in the end. That is a really high bar to clear. And guess what? They did it. The court granted the injunction. Just like that, Virginia had to stop suspending licenses because of this law. For the drivers, this was just a massive, massive success. They got exactly the relief they were hoping for. They could get back in their cars and legally drive again, while the rest of the case played out. But then, something totally unexpected happened. Something that took place completely outside the courtroom. And it changed everything. The entire legal landscape just shifted under their feet. So here's what went down. After the drivers won that big injunction, the folks over in the Virginia legislature, they took notice. They started looking at this law again, and by April of 2020, they didn't just tweak it, they repealed it. The entire law was wiped off the books. It was just gone. And since the law was gone, there was nothing left for the lawsuit to be about. So the court just dismissed the whole thing. There's a legal term for this. It's called mootness. And the best way to think about it is like this. Imagine you and a friend are arguing over who gets the last slice of pizza. But while you're going back and forth, someone else just walks up and eats it. Well, your argument is now moot, right? The thing you were fighting over has literally vanished. And this, right here, brings us to the million-dollar question. And I mean that literally. The drivers got everything they wanted. Their ultimate goal was achieved. But because the case was dismissed as moot, there was never a final court order, never a piece of paper that said they were the official winners. So, who pays the lawyers? That single question is what sent this case all the way up to the U.S. Supreme Court. Yeah, believe it or not, this whole massive case hinged on the definition of just two simple words in a federal law: prevailing party. You see, in civil rights cases, the prevailing party, the winner, can often get their legal fees covered by the other side. But the question is, who exactly is the prevailing party when the lawsuit just evaporates? As you can imagine, the two sides had completely different takes on this. The drivers were basically saying, hey, look, our lawsuit worked. The injunction stopped the problem, and that pressure is what made the legislature repeal the law. We won. But the state of Virginia came back with, whoa, not so fast. A judge never gave you a final permanent victory. It was the legislature that changed the law, not the court. You were never officially declared the winner. So how did the Supreme Court settle this? Well, the majority opinion was written by Chief Justice John Roberts, and it laid out a very, very clear definition of what it actually takes to be a prevailing party. And this quote from the opinion really gets right to the heart of their thinking.
The court called that preliminary injunction a transient victory, basically a temporary one. They said that just because some external event, in this case, the legislature repealing the law, happened to make that temporary victory a permanent one, well, that doesn't make you a legal winner when it comes to getting your fees paid. The court's logic here really rested on three main pillars. First off, they looked at old-school legal dictionaries, which have historically defined a prevailing party as the person who wins at the very end of the suit. Second, they pointed to their own past rulings, which require a win to be both sanctioned by a judge and be enduring or permanent. In this case, the court's order was temporary, and the permanent fix came from politicians, not a judge. And third, they basically said they wanted a simple, bright-line rule to avoid having more messy lawsuits just to figure out who has to pay the fees from the first lawsuit. So the final verdict was crystal clear. The Supreme Court ruled that because the drivers only managed to get that temporary preliminary injunction before the whole case went moot, they were not the prevailing party. And that meant Virginia did not have to pay their legal fees. But hold on, this was not a unanimous decision. Not at all. There was a really powerful dissent written by Justice Ketanji Brown Jackson. And she argued that the majority got this completely wrong and warned about some pretty serious consequences down the line. In her view, the majority's new hard and fast rule just didn't make sense. She argued that it totally goes against the whole point of the fee-shifting law in the first place, which was designed to make sure that regular people could actually afford to stand up and challenge unfair laws. So you can see the contrast here is just night and day. For the majority, a win has to have that final court-ordered stamp of approval at the very end. But for the dissent, a win is when you get meaningful court-ordered relief that isn't later overturned. They argued that preliminary injunction was exactly that, a real, tangible, court-ordered victory. And the dissent raised some really serious real-world alarms. They basically warned that this ruling creates a kind of playbook for defendants, especially governments. If it looks like you're about to lose a big case, you can just repeal the law, and boom, you get out of paying the other side's legal fees. The fear is that this could make lawyers hesitant to even take on these important civil rights cases, leaving people who successfully challenged a bad law, well, holding the bag for massive legal bills. So, what's the bottom line in all of this? The Supreme Court has drawn a very, very bright line in the sand. A win for the purpose of getting legal fees isn't just about getting the result you wanted. It's about getting that final, official, court-stamped piece of paper that says unequivocally, you won. And all of this leaves us with one big, lingering question for the future. By setting the bar for winning this high, is this decision going to change the entire strategy, the whole calculus for how lawyers and plaintiffs fight the next generation of civil rights battles? That's a question that the legal world is going to be wrestling with for a long, long time.